Hey guys, Sean Terry here, flip2freedom.com. Hope you're doing well. All right, in this video, I'm going to take you through a real estate purchase contract that we use, that we have the seller sign to get the property under contract. We're going to go through the actual contract and the other documents that we have the seller sign. I'm also going to do one more. I'm going to give you this contract package for free. There's a link in the description below. I think it says like F2F giveaways. You can click that link and you can download these for free, which is cool. So if you like making money, you like going out there and flipping houses, talking to sellers, getting properties under contract, doing deals where you can make 10, 20, 30, 40. Our average deal size right now is $38,000. If you want to do deals like that, do me a favor, click the like button if you could, hit the subscribe button, and let's get into it.
I can't take no loss, yeah. I don't even know what it costs, yeah. I hit the ground, then it go off, yeah. Hit the ground, then it go off, yeah, yeah. Run it, ooh. I really feel it's my time, think it's my year, yeah, yeah. I really feel it's my time, think it's my year, yeah, yeah. I really feel it's my time, think it's my year, yeah, yeah. I really feel it's my time, think it's my, yeah.
All right, let's talk about the contract package. So here's the deal. Maybe you don't know me. I've been wholesaling now for over 19 years. I got started back in 2003. Wholesaling houses local in the Phoenix market. I've done thousands of deals, hundreds of millions of dollars in wholesale transactions. Currently own apartment complexes. So when it comes to wholesaling, I pretty much have seen everything. Now, we pivoted in 2019 to go virtual all across the country. That was a big pivot for me, but it's been an incredible experience. All right, so part of that is being able to get the, or work with the seller to get the property signed and under contract over the phone. Now, in person is a little bit different because you can sit with them and you can go through the contract, but over the phone is much different. So you got to know what you're talking about, got to go through the contract, and we're going to do that right now. So I've got the contract package up here, and we're going to go through it real quick, and I'm going to make this quick video. All right, so now we got the contract package, right? If you see, it's about 2 pages. Then we have the authorization to sign listing docs. This is what allows us to list the property on the MLS and sign the documents. And we've got the authorization to release information, okay? So we're gonna go through this real quick. It's actually a really easy contract. So I want you to picture this. You're talking to a seller. You have a meeting of the minds. You've negotiated with them, and they wanted 150. You said you need to be at 120. And let's say you agreed at $130,000. So you say, great, okay, great. We got a deal at $130,000. What I'm gonna do, and you're gonna have the contract prepared and ready. Now, if you want to watch one of my previous videos, I talk about how to close over the phone, the 4-step process we use to close over the phone. But what happens now is that you're going to send them the contract. Say, great, Mr. Seller, are you in front of your computer? Now, the whole thing's going to be filled out. You're going to prepare for your success. The contract is going to be filled out. All the information is going to be in there except the price in your DocuSign. And then you're going to add in the price once you have the agreement on $130,000. Then you're going to send them the contract, and now they're going to receive it on the other side. And what's going to happen is now they're going to open it up. And now you're going to walk them through that contract over the phone. All right. So now you got this. Contract for sale and purchase, contract dated February 9th. With the buyer, you put your name or company information here, offers to purchase or sell, the seller's name and information there. The following describe real estate located at subject property, put the address, county, put the county. So it'd be Maricopa County if it was in Phoenix. Parcel number or APN. You can get this from REI Automator. This is the parcel number. Now, let me see if I can pull this up for you. And as we're looking at this, so that's the parcel number right here. And it says, witness, it says that seller in consideration of payments, covenants, agreements, and conditions herein contain, which on part of the buyer are to be made, done, and performed, has this day sold upon the conditions herein recited to the buyer the real property, legal description as, and it says to be filled in by the title company. So this is just legal language, essentially saying that they're selling the property on this property right here, and this is the legal description. Now, legal description essentially is where the property is located on the map. So if I go now, let me go back to REI Automator over here. And now you're going to put the purchase price. This purchase price is, you're going to have everything filled out. So you're going to have your information, seller's information, property address. You're going to have the APN. All this is going to be filled out. And prior to you getting on the phone with them, and you're actually going to close the transaction. Remember, we have a four-part section, four-part process that we use to close deals over the phone. Existing mortgages. Now, I'll put that link to that four-part below so you can have easy access to it. Existing mortgages. Existing financing on subject property will be current in all payments of the principal and interest, late charge, and escrow amounts required by the mortgagee. So this is basically just says everything has to be current. Escrow balance shall be calculated into the price and will transfer to the buyer with title. Buyer will take property subject to the debt. Now, this is right here. A lot, you're not going to use this on a lot of properties, but it gives you the ability to take title subject to the existing debt. Now, we're not doing any subject to deals right now because the current market condition, I believe, doesn't deem it's not prudent to do those transactions right now. You don't want to do those in a declining market. You want to do those when the market's starting to recover and then come back. The perfect time is when we're at the bottom. Then you want to do subject tos, and now you're going to have an increase in value. You're going to have better interest rates and stuff like that. So in this particular case, you want to have the option to do it. You could strike that and pull that out if a seller objected. All right, so let's get back into it. And let me go back over here. I'll show you where to get the APN. I'll just take this place in Nashville when someone's looking at. So if you got the APN, if I go here, it's this right here. It says APN, and this is right here. That's the APN. So that's where you get it in REI Automator. Legal description is this right here. You could actually take this legal description if you want, copy it, and then you could drop it here, or you could have the title company fill it in. All right. So now closing costs paid by, you could put an X there, seller, paid by buyer, or 50% seller, 50% buyer. This, remember, is up for negotiation, and you can negotiate with the seller on that. Insurance, as consideration for the purchase, the seller will assign all insurance policies on the property to the buyer, and seller will grant limited power of attorney to the buyer to deal with the lender and or insurance providers. Now, what the heck is that? So we have purchased over the years lots of properties that have fire damage. They have water damage. They have some sort of damage on the property. Well, this will allow you to work with the title company to get the actual proceeds for the house, even after purchase, right? You could get that after purchase if you have in contact with the seller. Now, you're able to, now I like to do it before the actual closing, so everything's done, and they work with the seller to have those insurance proceeds forwarded to us. But again, you might not do that. They might want the proceeds, and then they're going to sell the house. It just depends. And remember, everything's negotiable. There's no hard and fast rule. It's all within the negotiation. All right, now, risk of loss. If subject property is damaged prior to transfer of title, buyer has the option of accepting any insurance proceeds with the title of the property in as-is condition, or the canceling of the contract and accepting the return of the deposit. Seller agrees to deliver property to purchaser in present as-is condition. This is huge because we've done deals with sellers, and then the buyer goes and specs, and the buyer says, oh my gosh, the property's trashed. That's why you want to make sure you get some good pictures of the property prior when you're signing the contract, but they don't want to trash the place. We had someone go out, they took out all the appliances and took out all the fixtures, lights, ceiling fans, everything. Well, you can't do that. It's going to be an as-is condition of when it was purchased. All right, now, prorations. Real property taxes will be prorated based on current year's tax withholding, withholding current tax years without allowance for discounts, including homestead or any other exemptions. Rents will be current and or prorated as of the date of title transfer, and any and all condominium fees, homeowners association fees, and other assessments shall be prorated as the date of the closing. Okay, so those are just prorations. Defects. And this is something like with taxes. So if you're talking like property taxes is prorated to the date of closing. Same with rents, same with all these other fees in here. Defects. Seller warrants subject property to be free from hazardous substance and from violation of any zoning, environmental, building, health, and or governmental codes or ordinances. Seller further warrants that there is no material and or other known defects on the or facts regarding the property, which would adversely affect the value of the said property. So that's important because you're dealing with a lot of motivated, distressed sellers in this particular case. And you want to make sure that they're not in a legal lawsuit that maybe not recorded against the property or some other situation. You know, we've had properties where, we're working with a seller and they don't disclose that there's a septic system and the septic system pretty much imploded, and that has to get completely dug out in a brand new septic system put in. Well, that's an issue. That costs money to be able to get it done. All right. So you want to make sure the seller's disclosing everything. Radon gas, lead paint, it said lead-based paint and radon, a naturally occurring radioactive gas that may be present in health risk to persons who are exposed to it over time, may exist in this property. Buyer may obtain a risk assessment of the property by licensed inspector. Dangerous circumstances and conditions which cause said circumstance would be corrected at seller's expense before transfer of title. Now, we have had sellers want to strike that because they're like, well, I don't know if there's radon gas. I don't know if there's, lead-based paint or whatever. So it just depends. That's again up for negotiation. 99.9% of the time, we do not strike that. That is part of the contract. And it could be an essential out clause if we get into a lead-based paint situation. And it can become negotiable if there's a situation where our buyer goes, wait a minute, there's lead-based paint. It needs to be fixed before I buy the property, and it's going to cost $3,000, $5,000. In this particular case, you can have the seller in the contract. Now it's their responsibility to pay that $3,000 to $5,000. I bought a house in Phoenix a couple of years ago that we did a renovation on, and that property had lead-based paint, and it cost us, I think, roughly like $3,000, $4,000 to get it fixed. All right. Now, title, seller warrants. That's a seller will convey at closing good and marketable title to the property via a limited warranty deed subject only to zoning easements record as of the date herein. Subdivision and condominium declarations, covenants, restrictions, easements of record as of the date herein. And leases and or other encumbrances as specified herein in which the purchaser hereby expressly agrees to assume. This is basically just stating that title is good and marketable, meaning that means you can get title insurance. A title company will underwrite the title on it, and they'll insure that title. So you have to have a good and marketable title that can be underwritten based upon these items here. So prior to closing, purchaser may examine title to the property, and that is like if there's any like liens or judgments or anything. All right, those are called Schedule Bs. Schedule Bs. In the title, and you can able to basically review those Schedule Bs in the title, and the title company will clear those Schedule Bs so you can close. So purchaser, seller written list of objections affecting marketable title thereof, which are the Schedule Bs. Seller then has a 30 days from the date of such notice to satisfy and cure at seller's expense. which all this is pretty much done by title. This is just guaranteeing that you're going to get marketable title. And any valid objections upon delivery of the purchaser of evidence that all valid title objections have been satisfied, this transaction shall close as completed herein. If seller is unable to satisfy any valid title objection, then purchaser may elect to terminate this agreement by returning to the seller any and all surveys, title reports, appraisals, and any other documents provided to the purchaser and or accept such title may be able to convey and close this transaction as completed herein, subject to any title objection. Should purchaser fail to make any election within 10 days of receiving notice of seller's inability to satisfy valid title defect, then this agreement shall be terminated. So that just protects you that when you're signing a contract, you want to get good marketable title. You want to make sure there's no Schedule Bs on there, and Schedule Bs are all the items that need to be cleared for the title company to issue title insurance. But if you can't get clear title and the title company says you can't get clear title, then this agreement can be canceled. All right. Disclosures. This is an incredibly important part, and you definitely want to read this to the seller. Buyers agreeing to purchase the property for the sole purpose of making a profit. It is understood that the buyer is not intending to occupy the property as the primary resident. It is further understood that the buyer will determine the best method of making a profit, which may include, but is not limited to, may rent the property, leasing the property, assigning the property to another buyer, fixing and flipping the property, or selling the property to a retail buyer via the MLS listing service. So this tells them exactly what you are doing. You're going to make you're intending to make a profit. You don't know how you're going to make a profit. It could be all of these to be able to make a profit. Seller fully understands that the buyer and or representatives are not earning a fee or a commission from the seller. That is really important because you're not acting as a realtor. Seller should not expect any representation from buyer and or its representatives. All legal and financial advice in question should be answered by the seller's broker or other legal advisor. So that is critically important to be able to do. To be able to do that, and be able to. I'm just putting in the closing date. To be able to, let them know that they can talk to a legal advisor, and like I said, 99% of the people, they're motivated. They want to sell their house. They want to be done with it. They're just happy that you're going to work with them and help them solve that problem. Remember, that's the mission. All right, now back into it. Inspections. Okay, possession of the property and occupancy, tenants accepted with all keys and garage door openers will be delivered to buyer when title transfers. Leases and security deposit will transfer to the buyer with title. Then we have this one, inspections. This contract is contingent upon a 30-day inspection business day. Notice that. Inspection and approval of the property prior to the title transfer. Seller and the tenant, if any, will make property accessible to show partners, lenders, inspectors, appraisers, advisors, contractors prior to closing. So not only are they agreeing to be able to let you show the property to partners, lenders, you also have a 30 business day inspection, right? In period that would coincide with your closing date. So what's that mean? It means that and any time within 30 business days, if you can't sell the property, if you find something on the property that's affecting the value or whatever it might be, you can renegotiate with the seller or you can cancel the contract, and you can get out of the transaction with that inspection period. All right, so acceptance. This instrument will be combining contract when accepted by the seller and signed by both buyer and seller. If it is not accepted and signed by seller prior to, say, March 15th, in this particular case, you would do, you'd put, February 9th, right? Let's say you put February, give them like 5 days or whatever. Deposit upon acceptance, buyer will place in escrow any earnest money, an earnest money deposit of $100. You could do, $10. We typically do $100 on our contracts. We've gone up to $5,000 depending on how the deal is. 99.9% of the time, that's our EMD. With the title company, which will be part of a cash paid to the seller when title transfers, the deposit will be returned to the buyer if the title does not transfer in accordance with this agreement, and said title company will close the transaction. Closing will take place on or before blank. That is your closing date, subject to a 90-day period in which the buyer and seller shall be permitted to clear any title problems. That is your closing date, and you have 90 days after that to clear title if there are Schedule Bs. Now, we've been in contract with a seller before. We find out it has to go to probate. We have to go through a probate situation. The contract is still intact because we have that 90 days to be able to clear title and get them the ability to give us a good and marketable title. So that's important. All right, now back to this one. Let me see here. Okay, closing. 90 days default. In the event this agreement fails to close due to the default of you, the buyer, seller, sole remedy shall be what? Earnest money and fully liquidated damages. What's the earnest money? $100. So seller expressly waives any right to ascertain claim a specific performance, meaning they can't sue you for a specific performance. The parties expressly agree that the earnest money is a reasonable pre-estimate of seller's actual damages, which the damages of the parties agree are difficult to ascertain. The parties expressly intent for the earnest money to serve as liquidated damages and not as a penalty. So this is another out clause. For some reason, if for some reason you cannot close and you're actually in breach, in default, and you are in default of the situation, they will keep your $100 or whatever you put down for earnest money. That will go to the actual seller in this particular case for tying them up for that long. All right, now. Other agreements. This agreement contains entire agreement between parties with respect to the subject matter of this agreement and supersedes all prior agreements and understandings, both oral and written, between parties with respect to the subject matter herein. No representation, promises, or inducement not included in this agreement shall be binding upon any party hereto. So buyer agrees to purchase property and as his condition. These are any other conditions, and they could be, seller agrees to, leave the refrigerator or whatever the case may be. All right. Now in this part is time is of the essence. With this agreement, each contingency contained herein shall be satisfied according to the terms of the closing date, or this contract extends to provide the time for satisfactory or said contingencies. Each party shall diligently pursue the completion of this transaction. Each warranty herein survives the closing of this transaction. So we got governing law. So this is just time of the essence. So everyone's moving forward to get the transaction closed so it doesn't drag out for 6 months. Governing law, the agreement shall be interpreted in accordance with the laws of the state of, and you're going to put the state, you can put state of Arizona if the property's in Arizona, New York, or whatever. Servability in any provision of this agreement or part herein is held invalid, illegal, unenforceable. Such provisions shall be modified or deleted as to the extent rendered to the same valid legal enforcement. The validity of the legal and enforcement of this remaining provisions herein shall not in any way be affected herein. So basically, if something is not in agreement with the law, then this contract will be basically unenforceable and amended, but everything is within the law. So prohibition, this agreement establishes prohibition against transfer, conveyance, or encumbrance of the property. So basically, you can't encumber the property once you're in contract. So you got seller, buyer, signatures. And so this is the purchase contract. It's a bunch of legal language. What we typically do when we're talking to a seller, we're going to point out the main parts. Okay, this is the property. This is a legal description, whatever. This is you, the seller. Here's the purchase price. We're paying the closing cost. if there's insurance, prorations of taxes, we talk about any defects in the property, ask them if they have judgments on the property, and make sure there's clean title. There's nothing affecting the title. We go through this thoroughly with the seller. Inspections, we talk about that, and closing, default, and stuff like that. So we highlight the main parts unless, and this is another whole conversation, depending on their personality type. There's certain personality types that are highly technical. They don't like to get pushed. They like to read everything thoroughly before they make a decision. So with that personality type, we go through the contract, not skim it, but we go through it thoroughly. And then we'd offer to say, hey, listen, why don't we, you have the contract, why don't you review it? Why don't you go through it in detail? If you have any questions whatsoever, I'd be happy to answer those questions for you. If you want to have it reviewed by anybody, you can do that. Just do me a favor. If you could get an acceptance back to us by this date, that would be great. Now, that personality type will love the fact that you're giving them time and you're not rushing them through the process. All right, so now let's get into the authorization to sign listing docs and offers. This gives us the ability to list the property on the MLS and sign on their behalf. Now, be it acknowledged that we, and this is the seller, do hereby grant limited and specific authorization to Sean Terry's Real Estate Investments, for the property located at and the address as my attorney in fact. Said attorney in fact shall have full power and authorizations to undertake and perform the following acts on my behalf related to the property, and again, the property address. Seller specifically authorizes and gives permission to the attorney in fact to list the property on the MLS, the listing service, MLS, for the purpose of marketing and selling the property. This includes executing listing agreements, listing agreement addendums, disclosures, sales. Now, we have the seller sign disclosures about the property. The seller signs those. Sales contracts and addendums. The authority herein shall include such incidental acts as reasonably required to carry authorities granted herein. The authorization is effective upon execution. This authorization may be revoked when the above state one time power or responsibility has been completed. The authorization shall be automatically revoked upon the death or incapacitation, provided any person relying on this power of attorney shall give full rights to accept reply upon the authority of the attorney in fact until the receipt of the actual notice of revocation. So this basically gives us the wholesaler the right to list the property in its essentially full disclosure. Okay. So that's what that document. Now, this document is the authorization release information. This gives us the ability to pull, or the title company to pull any information from the title companies, right? I mean, from the HOA or from the mortgage, interest, attorney fees, any liens, judgments, anything like that that's encumbering the property. Instead of having to rely on the seller, we can send this to a mortgage company or a company that has an attorney that has a judgment and be able to pull a payoff on the transaction. So this is a letter of authorization, name person giving authorization, HOA phone number if they have it, bank information if they have it, signature, last four of the social, person giving authorization, and there you go. So this is important, letter of authorization, and then this is critically important to be able to list on the MLS. So that is the contract, and seems like long, but once you understand it, go through it. Most of the time, unless you have that very analytical person, you're spot checking through each section of it and explaining to the seller what they are signing. We do read on that one portion, we do read the disclosures to them thoroughly right here. We read these to them so they fully understand that. And there's no question. You can even have initial by that if you'd like. So hope this helps. Now, remember, you can get a copy of this below. All you got to do is click the link. I think it's like F2F giveaways, and you'll get a copy of our contract package. So you can do that. Do me a favor, hit the like, subscribe button, and thank you so much for watching. Also, too, if you want to learn how to wholesale, how to do deals, how to be able to talk to sellers, the 4-step process that we use to close completely in detail, then we have an entire course on this. It's called Bear Market Millions. The link is below. We have a whole entire training on it, show you how to pick cities, what to look for, how to make offers correctly. We give you our obviously our offer calculators. And it's the whole entire system, even how to dispo, how to list the properties step by step, the whole entire thing to be able to get your deals sold and make a bunch of money. Click that link below and follow that, and you can learn a ton in that free training. Hope this helps. Talk to you later. Take care. God bless.
I can't take no loss. Yeah, I don't even know what it costs. Yeah, I hit the ground and it go off. Yeah, hit the ground and it go off. Yeah, run it. Ooh, I really feel it's my time. Think it's my year. Yeah, I really feel it's my time. Think it's my year. Yeah, I really feel it's my time. Think it's my year. Yeah.